They never, they never came through. I think it was just a wear them out and they'll go away.
Mhm.
All right. Welcome, Gary. We all ready to go?
Yes, sir.
Okay. So I guess, Mr. Washington, we probably could have done this before Gary got here, but let me kind of tell you what we're going to be doing and then we'll get started. I'm going to have to ask you a bunch of questions to take up this plea of yours. And if I ask you something you don't understand, you need to tell me that. And you and I will talk about it until we're sure we're talking about the same thing, okay?
Yes, sir.
And also, if at any time you want to talk to Mr. Long in private, before you answer a question, you just tell me that. I have the ability to break you guys out into a private room where we can't hear you talk, okay?
Yes, sir.
All right. I'm going to call the case and my court reporter will swear you in and we'll get going. We're going to be on the record in case number 20, wait a second. I had two cases written down, 2020 CR 27 and 21 CR 29.
29.
It's the 29 case? Okay.
Yeah, 21 CR
What's the
29.
deal with the 2020 case, or is there one? Was that just a mistake?
I think that's just a mistake.
Okay. All right. Thank you. Then I'm going to call case number 2021 CR 29, caption State of Kansas versus Brian Washington. Would the parties announce their appearances, please?
May it please the court, Your Honor, State of Kansas appears through Assistant District Attorney Mark Brinkworth.
May it please the court, the defendant appears with his attorney, Gary Long.
All right. We are here set down to take a plea. First things first, I need to have the defendant sworn in. So, Mr. Washington, if you'd raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
All right. Mr. Washington, how far did you go in school?
10th grade, but I got a GED.
Okay, so you read and write okay? Is that correct?
Yes, sir.
All right. As you sit here today, I know you're in custody, but are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
No, sir.
Feel like your mind's clear today?
Yes, sir.
Do you know what you're charged with?
Yes, sir.
All right. And you know that you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial in this case. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Long would assist you throughout that trial. He could confront and cross-examine all of the state's witnesses, call any witnesses that you wanted called. If they didn't want to come to court, he could use subpoena power to make them come. At that trial, you'd have a right to testify, but you'd also have a right not to testify. And if you decided not to take the stand, the state couldn't use that against you. In other words, Mr. Brinkworth couldn't get up and argue to the jury, well, you should find Mr. Washington guilty because he didn't tell you his side. You understand all those rights?
Yes, sir.
Now, if we had that trial and at the end of it, you were convicted, you would have the right to appeal that conviction to the appellate courts. If you didn't have money to do that, a lawyer would be appointed to do it for you. You understand that?
Yes, sir.
Okay, so if we do this plea today, you're going to be giving up all of those rights and there's not going to be a trial of any kind in this case. Do you understand that?
Yes, I do.
All right. Now I'm going to share on my screen here and I want to know if you can see it when I get it here. The copy of the plea petition that was sent to me. Can you see that document?
Yes, I see it.
Does that look like the plea petition that you and Mr. Long went over?
Yes, sir.
All right. Now, there's a part of it here. Well, first I'll go down to your signature. There's a signature where it says defendant. Is that your signature?
Yes, sir.
All right. Now, here's the plea agreement part of this. I'm going to read it to you. Make sure that we all understand what the plea is. You're going to be pleading guilty to count 1. That's possession of methamphetamine, which is a severity level 5 drug felony. The parties believe your criminal history score is A. The parties agreed to recommend the aggravated end of the box with a recommendation for a dispositional departure to probation. That you would comply with that probation, which would require that you get a substance abuse evaluation and follow the recommendations while you're on probation. Is that your understanding of the entire plea agreement?
Yes, sir.
Has anybody else promised you anything else to get you to plead guilty today?
No, sir.
Has anybody threatened you or put any force against you to make you plead guilty today?
No, sir.
All right. Now, I see that the parties think that you're going to have a criminal history score. So I have to advise you the maximum that anybody can get for this crime. And I know it's in the plea petition here, so I'll go here, and it is accurate that the maximum that anyone could get is 42 months in prison and a fine of $100,000. That would include 12 months of post-release supervision. Do you understand that that's the maximum penalty anyone could get?
Yes, sir.
All right. Now I see that the parties are agreeing to recommend certain things, basically the aggravated box and the dispositional departure for probation. When we get to sentencing, I'm going to be listening very closely to everybody's recommendations, but I'm not party to or bound by them. And I can sentence you to anything that the law allows me and grant or deny probation independent of any agreement. Do you understand that?
Yes, sir.
All right. Mr. Washington, any questions for me about anything on this petition or anything that you and I have talked about today?
No questions.
All right. And knowing all this, you still want to go forward with this plea?
Yes, I do.
Mr. Long, do you know any legal reason why your client should not plead guilty?
No, Your Honor.
All right. Then I'm going to ask you, Mr. Washington, as to count one, which charges you with possession of methamphetamine, a severity level 5 drug felony. How do you plead, guilty or not guilty?
I plead guilty.
All right. I'm going to ask Mr. Brinkworth to tell me what he thinks the state would be able to prove if this case went to trial. I want you to listen closely because when he's done, I'm going to ask you if that's what happened, okay?
Okay.
Mr. Brinkworth, you're muted.
Judge, if this matter were to proceed to trial, the state would produce evidence showing that on January 14th, 2021, Deputy Michael Lopez with the Wyandotte County Sheriff's Office was assigned to the position of intake movement officer for the B day shift in the Wyandotte County Adult Detention Center located at 710 North 7th Street in Kansas City in Wyandotte County, Kansas. At approximately 10:20 a.m., Deputy Lopez took custody of the arrestee Brian Washington from the Kansas City, Kansas Police Department, Officer Edgar Estrada at the intake Sally Port. Mr. Washington was arrested and brought to the detention center on a separate charge. Deputy Lopez had Mr. Washington stand in the yellow marked box area so he could complete a pat-down search on him. Deputy Lopez placed a facial mask on Mr. Washington and then had him place his hands on the wall. Mr. Washington was wearing a long-sleeve black shirt and black and white plaid pajama pants. Deputy Lopez searched Mr. Washington's upper body first, and then as he started to search the waist area of Mr. Washington's pajama pants, he noticed they were tight around his waist, and he pulled the waistband outward so he could check for any contraband, and he continued with the pat-down. As Deputy Lopez checked Mr. Washington's left leg, he lifted the bottom of his pajama pants up to his calves, and then he checked Mr. Washington's socks. Deputy Lopez then had Mr. Washington place his left leg back on the floor. As Deputy Lopez began checking Mr. Washington's right leg, he observed that a plastic baggie with red tape containing a crystal-like substance had fallen between Mr. Washington's feet. He picked up the baggie and secured it in his pocket so he could complete the pat-down. And then he notified Sergeant Sage and advised him of what he had found during the search. Detective Simpson was notified, and she responded along with Detective Croning to intake, where Detective Simpson conducted a field drug test on the crystal-like substance, which tested presumptively positive for the presence of methamphetamine. It was weighed and showed the weight of the substance to be 1 gram and secured into evidence. And all those events happened in Wyandotte County.
All right, Mr. Washington, is that what happened? Mr. Washington?
I'm sorry, could you repeat?
Yes, sir. That's what happened.
Okay, thank you. I will find the defendant has freely, voluntarily, and intelligently entered into this plea. He knows the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and the defendant has acknowledged that factual basis. Therefore, I will find that he is in fact guilty of count 1, severity level 5, drug felony, possession of methamphetamine. I'm going to order a pre-sentence investigation, continue sentencing till we receive that. Let me give you a couple of dates, gentlemen, as to when we might set that. My assistant gave me May 24th at 9. How does that work?
That works for me.
Works for me as well, Your Honor.
All right, May 24th at 9 by Zoom. We can go off the record for the rest of this. Anything, I guess I should advise Mr. Washington, as a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. And Mr. Long, do you have any kind of motion as to bond?
Yes, Your Honor. I was hoping the court would let me be heard on bond. While this is a presumptive prison case, as the plea agreement, parties will be agreeing to recommend probation. Mr. Washington has already been evaluated by RADAC, and they've recommended outpatient treatment. And so we would ask the court to consider an OR bond in this case, so that Mr. Washington can actually get himself into treatment and begin the process of starting to comply with the things that we know the court is going to order him to do as part of his probation.
Mr. Brinkworth.
Judge, given the low weight of the drugs that were found, as well as the fact that he has had the substance abuse evaluation and it does recommend treatment, I don't have a problem with the bond being modified, Judge.
All right, I'm going to give you an OR bond, get you out today, Mr. Washington. Here's the deal, though. You understand that these parties have agreed to recommend to me probation. I'm assuming that you're going to do all the things you need to do before now in sentencing, and I don't see any reason why I wouldn't follow that. But if some reason you were to, say, disappear on us or not follow through on your treatments, things like that, I might have to reconsider that, okay? All right. So I'm going to grant him an OR bond. I have one other question. We're going to be off the record. Mr. Long, on the PSI request, there's no phone number or anything. Will that be sufficient for probation to be able to get him set up for a PSI?
I think it will. I don't know that. Do you have a phone number?